Hi there, my name is Maurice Flynn and I'm here today to talk to you about 12 steps to help you adapt and thrive under the GDPR, our new data privacy legislation. Thank you for joining today. Just a few words on myself. My background is worked in related data and technology spaces for almost a couple of decades now, and in the last couple of years been working with tens of companies preparing for GDPR, and I've tried to capture that learning, that approach, the solutions we developed together in a book which I've published. I'm just going to take you through the headlines of that today, trying to give you a useful summary of how you can do this on your own. Okay, so let's get going. Keep this as tight as possible. I'm screen sharing here, so bear with me as I scroll down to the different sections with the screen sharing device. The speed is sometimes a little bit slow, but I've tested beforehand. Once we get into the main gist, it works perfectly well. So just a couple of words in terms of the content. First of all, disclaimer, I'm not a lawyer, so I don't give out legal advice and shouldn't and wouldn't. This is more of a project planning approach of how companies can do this in order to maximize their chances of getting a good project plan in place in order to enable them to ensure compliance. But as always, everything should be checked and double-checked with your lawyers and legal experts. It's particularly relevant for companies with limited resources, as most of us are these days, trying to get a step-by-step approach. Okay, so just scrolling down and diving in. So the core of this content is based on a 12-step framework that the Information Commissioner's Office in the UK, for our GDPR authority in the UK, put together a couple of years ago now, I think, originally, and then been updating quarter by quarter as the GDPR deadline approached. And what I've done, though, where their 12-step framework has had to be necessarily top line in places, I've turned it into a much more detailed plan of action so that companies and individuals, even with less experience, can be confident as to how to implement this this plan of action. So, starting with, first of all, what have we heard about GDPR? What is GDPR? One of the main issues here is that GDPR, like all laws, will ultimately be tested and evolve in the UK courts of law, as all law is, and in the other respective countries, of course. And therefore, until that starts to happen extensively, even our legal experts have to tell us that everything is based on opinion rather than factual certainty based on case law. Of course, we update our thinking as that case law comes about, but at the same time we can't wait for that. We still have to be compliant as from the launch deadline of the 25th of May. Okay, so just getting stuck into the first section here. What are the key principles for GDPR preparation coming out of the authorities that each of the European countries have put onto this to advise us? So, first of all, data privacy management involves everyone in the company. It's not just a job for the data guy or the technical guy or the legal lady. It must reach everybody because we all work with personal data, and even if we don't do it on a regular basis, we borrow people's laptops, borrow people's phones, and may come across personal data in that context. So everyone needs to be aware of what GDPR means, what are the rules, what are the legal constraints, so that we don't make any silly mistakes. Secondly, we all need to take responsibility. The authorities, such as the ICO in the UK, recognise they can't police tens of millions of companies, and so the decision has been to hand it to the companies themselves to police themselves based on the law itself and the guidelines from the likes of the ICO, and indeed report themselves when they fail in any respect in order to mitigate any negatives coming out of that failure. We'll talk more about that. And thirdly, we evidence the work we're doing, i.e. we document it so that we can show what we've done across these 12 steps, because obviously if we can't evidence it, we can't defend ourselves ultimately in a court of law if required. Second point here, there's been a lot of scaremongering around the big fines that have been threatened by the ICO, that have been built into the law, 20 million euros or 4% of worldwide annual turnover, some of the big numbers that are often quoted for, for compliance failures. But most of the authorities have been clear that initially at least their aim is not to put companies into financial difficulty, but to help them comply and only use the penalties and the fines if companies are showing no interest in compliance or are making major errors and have to be made an example of. So the smaller companies doing these 12 steps, we should be well able to defend ourselves should we make mistakes along the way, which of course often does happen. Okay, then final point, there's lots of existing laws, of course, that we currently follow: employment law, ID, national ID, identity documents in some countries, freedom of expression laws. Those don't go away, and GDPR just intertwines with those, like any new law, and affects them around personal data, and we'll come on to just define what we mean by that. There's also new laws coming up. One that relates to GDPR in a big way is called e-privacy. It was due to be clarified, if you like, over the summer. It's now being kicked down the road, and some experts say we won't get a clear view of it until 2020. But when it does come in, it will deal with how we communicate as businesses electronically, and therefore it will overlap and act on top of GDPR. But for now, we know what's happening to GDPR, so we're going to crack on with our plans for that. Okay, so let's get on with the first step, and that is training and awareness, and that's what we're all doing here today. If we don't raise awareness of GDPR within our businesses from top to bottom, then how can we expect staff to deal with personal data in a compliant way? So let's just clarify a few extra points around personal data and GDPR. So GDPR, General Data Protection Regulation, came into force, if you like, on the 25th of May this year. And the idea is to unify and strengthen our approach to protecting personal data across all of the countries within the EU, the EEA, and of course the UK pre and post Brexit. Brexit doesn't get us out of this. This has gone, it is in the process of going into UK law as we speak. So it's relevant for all companies dealing with personal data from people within the EU, EEA region. Some lawyers are arguing that it can be interpreted as meaning even more than that, but that seems to be the guidelines we're getting from the authorities such as the ICO so far, so that's where we will focus. So what we need to do is put in plan, and many of us have already done this, training programs top to bottom of our companies, and then we, of course, as we said before, we need to document those training programs so that we can show that we've done them and refresh them on a regular basis. And as often is the case with new laws, documentation is really important, so we do have to get our paperwork in order and probably put together some kind of a GDPR folder where we show how we're following all of these 12 steps. So here's just some simple examples that I've thrown together. So step one, in terms of our training documentation, we need to have some kind of a policy statement that says we as a business are training on GDPR from top to the bottom of the business. We need some kind of procedure underneath that says, here's what we're doing for that training. And of course, this will often just merge in with a normal training program that most companies have these days, small or large. Some sort of evidence that we're taking our training materials from trusted sources, starting with the likes of the ICO, and then some kind of evidence document showing how different levels of management have completed the training program and will be refreshed on a regular basis. All of that's pretty straightforward, signed and dated as always at the bottom, so that we can add it to our documentation folder should we ever be audited in terms of our compliance across these 12 steps. So let's move on to the second step, and I'm glad to hear that most of these steps are fairly straightforward and are kind of logical in what we'd always do around a corporate project, and a couple of them are quite new and much bigger. So we'll skip through the simple ones and focus on the more complicated ones. Second one is putting together some kind of resource on a GDPR project team. If we don't resource it, it's not going to happen. If there isn't some clear leadership on the team, things don't happen within the business. And therefore, if we don't do that and then document that, if we're ever asked, we'd be hard-pressed to prove that we were taking GDPR seriously. Now, you may have read that some larger companies, typically with a few hundred employees, but more importantly, handling lots of personal data, are going to be required to have a so-called data protection officer. Now, this is not something to be lightly allocated to the youngest member of staff. It's someone who's got extensive experience and training in legal data compliance matters, but fortunately for most companies it's not mandatory under GDPR. So what most companies do, if they don't need a formal data protection officer, is have a lead person on GDPR. They could be called a data compliance manager, for example. It doesn't really matter what we call them, as long as they're supported by a cross-functional team, so they can get these steps supported by all of the key departments. So marketing help them, finance help them, IT help them, sales help them. So again, this GDPR compliance process is not just one person trying to do everything, but is flowing and supported by the full business. So as always, on the second step around resourcing, we need to have our documentation, some kind of a policy statement, a bit of corporate blurb saying, yes, we resource this project and always will, some kind of procedures to name who the lead on the project is and how much time it's taking up of their time. And this is obvious to some of us, particularly from maybe larger companies, but smaller companies, often this type of project is handled on the fly. It's not to say it's not done well, but most of this information is kept in people's heads. But under GDPR, it's really important, according to the ICO and the other key bodies, that we document it so we can show it to an inspector should that problem ever arise. Okay, on with step 3. Now this is a much more important step and tends to be the step that takes the most time for most businesses. And I'm calling this the data and risk audit. You can see it called different things in different companies, but essentially what it means is we need to put together a big list of all of the personal data that our company uses, comes into contact with, and answer some questions around that, kind of who, what, where, and why questions. What personal data have we got? Where do we keep it? What do we do with it? How do we protect it? Why do we have it? And that allows us then to do a risk assessment to say, okay, well, how could that personal data leak from the business, which would be a compliance failure, or indeed be deleted by mistake, which also would be a compliance failure. So this means data that's stored in official places and data that's forgotten on laptops and desktops. It means non-digital data as well as digital data. So as you can straight away see, putting together this type of audit does take a little bit of time, particularly the first time we do it. Okay, but let's just go back to the definition of personal data under GDPR, because this is also an area of confusion for many companies. So personal data under GDPR is much more widely defined than you might initially think logical. So it's basically any data that can be used to identify an individual, resident within the EU, EEA geography, but it doesn't just mean obvious stuff like email addresses or your phone number. It also means data that is something called indirect personal data, which could help identify someone indirectly if combined with other data. Now, the classic example of this is what our technical friends call IP addresses, for example, and this is kind of where you would access the internet, say, your gateway to the internet. Now, you may ask, how would that identify me if someone knew my IP address? Because it could be someone else in my office, it could be someone else in my home. But the point is that because it includes indirect personal data, that IP address combined with other data, such as your name, could identify that it was you on the computer at that time and you using the IP address, and therefore help track you down. So as a result, because of this requirement to audit both this big long list of direct and indirect personal data, it becomes a much bigger challenge, certainly the first time we do it. So most companies haven't got this in place already, and if they're a large company with a lot of resources, they may be able to put some technical expertise, software and tech teams on to help collate this documentation. Most companies I talk to don't have that resource or expertise or access to either, and therefore it tends to be a fairly manual process supported by software the first time through. So let's have a look at what this might look like. So again, I put together some forms that allow us to tackle this challenge in a way that even a smaller company with limited understanding of the jargon should be able to work through. So we need a policy saying that, of course, we've got some kind of an audit process and we update that every quarter and reflect on it on an annual basis, blah, 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 usual sort of corporate policy approach. But then most importantly, this is what the audit could look like. Now, it doesn't have to look like this. If you go on the ICO website, they've got their own model for these audits. But this is the way, having done this with tens and tens of companies, that I found it easiest to do in a way that didn't cause total confusion. So let's just go down from the top. I'm just going to skim through this. So at the top here, what I've put is the questions we need to answer in this audit. And I've split them down into different groups that might be sharing personal data. So the first group is contracted sources, so our customers, our suppliers, our business partners. The second group are non-contracted sources. We've got no contract with these people, might be sales and marketing prospects, recruitment prospects. And the third group at the end there is our employees, who are kind of a special case under the contract. And then what you'll see then as I scroll down is that first thing you need to answer is, what is the personal data we've got? And luckily we can group this into categories, so contact information, name, address, etc. Do we have that for our company, the organizations and people that we've contracts with, yes or no? Do we have them for people that we don't have contracts with? Yes, we often do. People send in CVs, we chase sales leads. Do we have it for employees? Almost certainly. And then what question you need to answer is, do we have demographic information such as age, education, genders? Do we have financial information such as bank accounts? Do we have other types of unique identifiers such as usernames and passwords? If, for example, employees are logging into our business systems, of course we do. Do we have information about their businesses? Well, we would have that on our clients and our marketing prospects. Often the answer is yes there. Do we have so-called digital data, such as the data we gather on our website and people click on our website, such as IP addresses, the browser they're using, the internet service provider they're using? Some of this may be hidden in our website technical system, and our IT team may need to help us work this out, but normally we're capturing some of this data. Do we use images of people and capture videos of people either for marketing or security purposes, such as CCTV? Do we gather special category data? Now, this is extra sensitive data such as race, ethnicity, medical records. There's a set of types there, and that needs to be extra carefully protected because it's high risk of causing reputational or financial damage if it leaks without permission. Then, once we've identified the categories of personal data we have for these different types of people that we deal with as a business, we then need to answer these other questions, such as where did we get it from? Did we get it from the data subject, that's the individual, or did we get it from another business, or did we get it from the government, maybe in some cases? How long do we, and what do we use the data for, and how long are we holding on to it for? Under GDPR, we can't hold on to personal data indefinitely. Everything should have a deadline by which it's fully being utilised and then can be properly deleted and safely deleted. So are we using it for contacting customers or employees? Are we using it for business research? Are we using it for helping people log into our systems, marketing, sensitive data checks? All of these use cases need to be listed, and the period of time that we've agreed to hold the data with the individual or for another rationale should be listed there. What is the legal basis for holding on to the data? We'll talk more about this in the next section, but these are the legal basis by which we can use personal data under GDPR. If we have a contract with the person that agrees that, if we have a legal obligation, such as for special category sensitive data, if we can argue legitimate interest, which is balancing our interest as a business to communicate with the interest of the individual, not to be surprised with endless spam, essentially. Do we have consent for some of our marketing activities? Do we have public tasks to fulfill, such as legal cases or scientific research? Are we trying to save someone's life, in which case, of course, we can share their personal data? And we'll come back to those in the next step. Who has access to the personal data in our different departments, our finance people, our HR people, our marketing people? The key thing here is access to personal data should be on a need-to-know basis. If everyone can access everything, that's a major compliance problem. I think most companies would recognise that. Who do we share the data with? Other businesses, back to the government, such as HMRC, for tax reasons. Of course we do, we need to just note that down. Then moving on to the risk analysis stage, where is the data stored? Is it stored in IT systems in our offices? Is it downloaded to desktops? Do we have paper archives in the office? Do we use portable devices? Can be lost in taxis or left on trains? Do we use cloud systems such as email in the cloud and so forth? Of course we often do. How do we protect our data? Do we use secure premises with locks and alarms? Hopefully we do. Do we follow best practice in terms of IT, firewalls and hacker protection? Do we use strong passwords and limit access to personal data? Do we pseudonymize data? This just means hiding personal data under a pseudonym so that we're looking up a, say, account number or an employee number rather than by their name. So it's a little bit more protected than exposing all of the personal data. Do we anonymize data so that you can't see what the individual is doing? Do we encrypt data when it's moving when it's outside of secure settings, such as when we're moving sensitive data on a train, on a laptop? Do we delete data securely and properly at the end of an agreed period of time? Do we have policies for all of this? Do we have contracts with any partners we share data with to make sure they also understand these rules? Coming out of that analysis, we're nearly finished on this section, you'll be glad to hear, we can then work out where the high GDPR risks are. Is it through an IT hacker hacking into our systems? Is it through physical break-in to our offices or homes? Is it through malicious action by an employee or a visitor to our offices? Or is it most probably through human error? Lost devices, emails open when they shouldn't be opened, phishing emails, for example. This is probably the biggest risk area for most companies. And what are the actions we're going to take to tackle the highest risk areas first and the lowest risk areas when we've got the time and resources to do? So there, in a very quick nutshell, is how we complete the data and risk audit. Once we've documented that, and it is a bit of a workload the first time through, we've got a documented data and risk audit that is good enough to present to an inspector should ever a complaint cause an inspection to take place. Okay, the next few steps get a lot simpler after that. Step 4, planning the lawful basis for holding our data. We've already done that within the previous step. So smaller companies will find that the audit has covered this off. But just what we mean by that is these 6 legal bases by which we're allowed to hold and use personal data under GDPR. So as just to recap, if we have the consent of the person whose data it is, we can then use that personal data for the agreed period of time. If we've got a contract with them and it's stated there, then that contract allows us to use the personal data. If we're using it under existing laws, such as employment records for employment law, if we're trying to save someone's life in a life or death situation, we can use their personal data for that. If we have public tasks, such as legal cases to respond to, then we can use personal data for that. And if we can justify legitimate interest, which, as we said, our business legitimate interest to communicate and grow, with the legitimate interest of the recipient of any communication not to feel bombarded, harassed, and having their privacy invaded. So we talked about that in the audit, and we filled in some documentation in that previous section. So for smaller companies, we've probably done enough, but if companies have big data sets, they are considering setting up an extra document to make sure they've really captured all of the data around the legal basis for holding that data, so they have that to demonstrate should an inspection ever take place. And again, here is the document that I personally use for that. I'm not going to go through all the detail there, but again, we're just laying down very clearly with our contracted partners how we look after their data and restrict its use and delete it within an agreed time frame, and then how we do the same with non-contracted businesses and individuals. Okay, just keep an eye on time. Let's crack on, move through the next steps. Step 5, correct consent and legitimate interest. I'm going to spend very little time on this one because I think we've covered a lot of the key points off already. This is just drilling down into the areas of correct consent under GDPR versus legitimate interest, which is what a lot of companies are looking at when they're trying to decide, particularly around things like marketing data, are they allowed to use that data still, that personal data, under GDPR. So consent under GDPR has changed and become a lot tougher. So let's just recap on what consent means under GDPR. So consent must be freely given, cannot be forced, needs to be very specific. So I give consent for the data used for this, not just be stuck in a database and used for everything. It needs to be informed. That means the individual giving the data needs to know what I'm talking about. We'll talk about privacy policies and how those need to be clearer to ensure everyone is informed. And it must be unambiguous. We can't use double negatives to confuse people into giving their data. We can't have pre-tick boxes anymore. They have to tick a box to give their consent, do a positive action. And consent agreements can't be hidden in T's and C's. It must be front and central where the data is captured. Now, because consent is a lot tougher now, a lot of the time it won't be appropriate as a legal basis for using personal data. So we look at the other legal basis first, such as do we have a contract with the person? Is there another legal reason for using the data? Can we argue legitimate interest, particularly around business-to-business communications in countries such as the UK? But certainly if we can't use all of those bases, then we come back to consent, and for some companies that means they have to reconsent consumer databases that have been gathered over time and they don't have consent clearly documented. Okay, so we mentioned getting consent, people need to be informed about that. So how do we make sure people are informed about when they're giving the consent? Well, we generally do that through our privacy policies. And privacy policies have to be rewritten under GDPR in most cases, because most privacy policies are stuck on a website. They've grown up over the years into a big, complicated document. Nobody reads them and nobody understands them, apart from maybe the lawyer who originally put them together, because they're full of jargon and sort of mumbo-jumbo. And often when you read them, most of it is not about data privacy. So we need to rewrite the privacy policies, and what we need to be clear about is the legal basis under which we're going to be using the personal data. So is it consent? Is it legitimate base? Is it legitimate interest? Is it for employment law purposes? And the period of time around which we're going to hold on to that data and get their agreement of the individual. We also need to mention the privacy policy that the individual has the right to complain to their local authorities, such as the ICO in the UK, and also they have other rights around this personal data. They can ask us what personal data we've got about them. They can ask us to send them the personal data in a standard file format, electronic or hard copy. They can ask us to delete personal data, which, unless we've got a legal reason not to, we have to comply with. They can ask to opt out of automated decision-making with their personal data. We'll come on to data requests which relate to these rights, but we need to state all of these data requests, all these rights within our privacy policies. So straight away you can see most privacy policies haven't done that before the 26th of May. That's why most companies have or are currently rewriting their privacy policies to cover off these new points. Luckily, once you do that, privacy policies tend to be a lot shorter, and the ICO and the other authorities are also encouraging us to try and write them in more human language, so people actually can read them, people actually can understand them. Again, then we can argue, we believe people have been well informed. So that's privacy policies, and I'll come on now to the next step, which relates to some of the points we were talking to there. Just skip through some examples there in the interest of time. Okay. So, next step, data subject access request. So, step 7, this is when we get a request from someone saying, tell me what personal data you've got, I want it deleted, I want it to be forgotten, I want it amended, etc. So, the key issue here is nobody knows how many we're going to get of those, and therefore what most companies are doing is responding to them partly manually using the software available, and then only scaling up their solutions and response mechanisms if there is enough demand. And again, you can look on the history of data requests to see if you expect to get lots of these in or not too many. Now, the key thing under GDPR is, as we say, they can ask for information about the personal data we've got on them. They can ask for it to be deleted or amended if it's incorrect, to restrict processing of that data, automated processing. They get the data sent to them in a standard file format, and we've typically got 1 month to respond to these requests. We can ask for an extension, but most of the time we need a process to respond to that for 1 month. So the process I generally recommend is in about 1 month time frame. If we've got a lead person on these data requests, the first week maybe or first few days is just about clarifying the requests, make sure we understand what they're asking for, getting them to authenticate their identity, just to make sure we're sending data to the right person. Then there might be a couple of weeks of gathering the data together, working with the different departments to do that, and then a final week to get it all approved by management and complete the task within the first period. And as always, it's no use us just having that process in our mind. We need to write that down within a GDPR folder or process document so that we can show the business knows that it needs to complete these processes within the 30 days. The next step, similarly, is a new process for many companies, and that's a data breach process. So data breach is when data leaks out of the business. Under GDPR, we need to respond to that, and in fact, respond to that within a 72-hour period of time. Now, most companies don't have that process documented down, and as a result, risk failing that time frame. Now, what we need to do is, first of all, we need to identify that a breach has taken place. Initially, it may be just a suspicion, so we need to qualify that a breach has taken place, that data is leaked out of the business or being deleted on a large scale. We then need to assess the risk of that data causing financial or reputational damage to the individual on a large scale. If that's not the case, then the reporting process can be internal. Obviously, the ICO couldn't cope hearing that every lost laptop, every lost mobile phone. We want to respond to companies that have lost large amounts of sensitive data. But we still need to complete a data breach report and draft that report within 72 hours, even if we're not submitting that anywhere outside the business. If there's a large-scale risk of reputational financial damage, then we need to report that to the ICO, start the reporting process within 72 hours with whatever information is available. And if the individuals are at high risk of damage, we also need to report to them. So again, we need to have that 72-hour process written down somewhere within a corporate document to show that new members of staff know where to look when they are trying to work out what our process is for this step in terms of GDPR compliance. Okay, so those are kind of the biggest processes and the most important ones for most businesses. The remainders are going to be relevant for some businesses and not for others, so I'll be able to skip through them quite quickly. Data transfers, so when we transfer data elsewhere outside the business, if we're transferring to another company, we need to make sure that they're also aware of GDPR rules, and we need to hold them to that through contracts, or if it's an internal company, through internal processes. If we want to transfer it to another country, then there are some constraints on that. And what the EU have done is they have approved certain countries, there's about 15 of them now, I think, on a list that we are allowed to share personal data with these countries because they've got good data privacy protection. And then if we want to share it further than this approved list, we have to make sure that we've either got a contract with the business involved that we can hold them to GDPR compliance no matter where in the world they are, or an internal set of processes if it's another office within the business, so we can 100% guarantee that we can hold them to GDPR compliance. So because of the risk involved, that's probably one to refer to the ICO, get onto the ICO helpline if it's something you need to do on a regular basis. Okay, last few steps, and then we'll have a few minutes for any questions. Sensitive data, such as children's data and the other sensitive data that we touched on, medical records, financial records, criminal records, these are just as protected as always. We can only use this data if we have permission or if we've got legal reasons to use it. We can only use it for the stated purpose, and then we need to protect this data very carefully under lock and key, electronically or physically, and then delete it securely as quickly as possible. So no let up on the restrictions on this. A couple of new data types that have been added into the sensitive data clauses. Genetic is one of those. But for most companies, if we are using this data, we're already having to protect it in the same way as we have to under GDPR. Okay, last couple of steps you'll be glad to hear. So privacy by design, I think, is the next one, which you should see just popping up on screen just a moment. So privacy and protection by design, what this means is we just need to have an understanding of this for most companies. If we're a bank, this is a huge project taking several years, might do an ISO 27001 to get there. For most companies, what this means is what we've already done in the previous steps. One is we plan for failure in advance and we fix the high-risk areas sooner rather than later. We've done that through the data audit and the plan coming out of the risk analysis stage. Secondly, we have need to know access to personal data, and we keep personal data under lock and key otherwise, and we don't open access to everyone. So protection of that data is built into the systems we use. We follow best practice in everything we do in terms of our IT protection, in terms of our internal processes, so we don't leave personal data open and exposed. And if we've done the other 12 steps mentioned here, for most small to medium-sized companies, we'll have got a good example of privacy by design through that. One last thing to mention, but I won't go into a lot of detail, data protection impact assessment. This is a process to normally talk about in this section, which is for assessing high-risk projects. So say you're moving all your data to a new system, brand new IT system, so it's a high-risk project, and so it's like a mini data and risk audit just for that project. And off the back of that, you identify the risks in advance before you even start the project. Now again, most of us would do this for a thorough project plan, but we all know with smaller businesses it sometimes gets forgotten. Not that it doesn't get done, but it's done in people's head and on the fly, which is not accepted really under GDPR. It has to be documented. Finally, step 12, project plan. We've really got that already. That is the project plan to deliver these 12 steps. In the short term, to deliver the high risk and tackle the high risk areas. In the longer term, to tackle the low risk areas, when with the time and resource to do so. And this is what's really important, a risk balance approach, because if we don't take a risk balance approach, we're going to rush, try and do everything at once, and we're going to fail on the high risk areas, which is the last thing that's needed. Okay, I'm just going to flip back to the presenter screen now, see if there's any questions come up so far. Okay, let's do a bit of technical problem on the screen. Yeah, just to answer the questions in terms of materials, I'll be able to share a summary note on the documentation as a follow-up, just to answer that question. Some people seem to have some difficulty viewing the slides. It's a screen share connection I've been using through the BrightTALK screen share, so we'll follow up on that and check. And yeah, if there are any direct questions on some of the content there or GDPR questions, feel free to pass them through to BrightTALK, and then I can answer those as best I can as they come through. Just going to check if there are any other GDPR specific questions coming through there. Can't see that there is. Okay, yeah, apologies, looks like we did have some screen sharing problems there. Not sure why that is. I'll follow up with the team, find out about that. Apologies for the difficulties there. Some of you are mentioning some audio problems. Again, not sure why that is. We're obviously using the standard software for that. Appreciate those of you that have kept going through, got some good feedback from those who were able to see the content, so appreciate that. And we'll follow up directly and try and answer as many questions as possible. Thanks for your time and appreciate your time with us today. Cheers for now. Bye-bye.